Very good afternoon to all of you. It's my pleasure to introduce the next speaker, Mr. Vijay Shankar. He goes by Naavi. Naavi is the founder and chairman of Foundation of Data Protection Professionals in India, dedicated to privacy and data protection in India. Naavi is also the founder of Naavi.org and a pioneer in cyber law. Naavi is a thought leader who has developed data protection compliance standard of India as a unified framework for data protection in India. Concepts such as data trust score for GDPR, data valuation standard of India, etc. Brief description of the talk. Naavi will be discussing the shape of the new law on data protection that Government of India is planning to bring in as a replacement of the Personal Data Protection Bill 2019, which was recently withdrawn. Naavi will discuss the concerns of the industry, privacy activists, and how the government is proposing to meet the expectation of the industry along with privacy activists and national security concerns. We welcome Naavi, sir.
Thank you. Good afternoon, friends. We had an excellent session from Mr. Chennai. I'm not as bombastic as he could be, but I think that was a good introduction for whatever I'm going to speak now. He was talking about education, awareness, and training. Okay. Now, the topic which I have chosen is something which the government ought to do. So, I don't know whether they will actually do that. So, to that extent, I cannot say it is talking about something which is definitely going to happen. But it falls more in the realms of education in the sense that all of us are professionals with a lot of experience from different areas. In fact, we would be very happy if the government listens to us and creates a law which is perhaps something which we all feel would be useful. Okay, so maybe you can say this is more in the light of education because I am going to speak about from our past experiences of various data protection laws, what should be the ideal form of the law. Those of you who know me, I have the habit of talking things which maybe in the future, okay. So this also is something like that, and we are trying to follow it up. In fact, you know, most of you that I work with that Foundation of Data Protection Professionals in India. Our next Indian Data Protection Summit, IDPS 2022, we are focusing on this shape of things to come. To the extent that we will discuss the current privacy practices world over, what happened in India, what is happening in India, and what should happen. Probably, at the end of our conference, we would like to build a document which we should be able to give it to the government. Now, of course, government is in a race with us. They say we will bring out with a draft next month itself. If they bring it out, we are happy. Okay, if they bring it out, we will discuss that. If they don't bring it out, we will ourselves give them a draft after the seminar is over, so that there is no need for waiting. That is our idea. I am already putting certain thoughts on my side, so probably all of you should also look into it and contribute your thoughts. So, we are looking at the emerging data protection scenario. Of course, we were all a little bit, say, taken aback when the minister actually withdrew the bill. And most of the people actually feel that there is a vacuum in the data protection law. If you go to any international market today, perhaps they all have a perception there is no law in India. Okay. But we know, as I think he already mentioned, that we have Information Technology Act 2000, which has got in it section 43 capital A, which talks about various principles of privacy with regard to sensitive personal information. And that goes to the extent of having a privacy policy with a notice, getting the consent, because this is the most important aspect of privacy. Then data minimization, purpose orientation of collection. It even has cross-border restriction. It makes somewhere a mention that it should be transferred only to such countries where you try to have adequacy of protection taken care of. Only thing is, when it came to regulator, in the Data Protection Act, if it had come, PDPB, we would have had a dedicated regulator. So perhaps the implementation would have been better. Now, in Information Technology Act, we have got two regulators. One is the civil regulator who is the adjudicator. There is an adjudicator in every state and every union territory. And he talks about providing compensation in case of any contravention. And he is none other than the IT secretary of the state. So no need to appoint any new person. The current IT secretary of every state is the adjudicator. He has got the powers to grant compensation arising out of any claim by any person regarding contravention of Information Technology Act. Now, that person who claims compensation can be a data subject who has suffered some loss because of some infringement of security related to personal data. That is, personal data has been compromised, misused in some form. Now, there was another regulator who was in the background who suddenly seems to have risen up like Kumbhakarna. Okay? It is CERT-In. Okay? CERT-In has had exclusive powers as from the day Information Technology Act 2008 came into being, because unlike other countries where there are CERT-Ins as organizations which are more like, say, helping the community in collating the information security incidents and giving some advisories and other things, Indian law actually gave a statutory position to the CERT-In as an organization. It declared that they are going to be the nodal agency for information security in the country. And the Director General, amongst other things, has got certain duties, he has got certain powers, and his powers include that if anybody contravenes the directives of the certain Director General, he is now called Director General, the Director General can initiate prosecution for imprisonment up to 1 year. So I think that is quite a powerful power for an executive of the government. Okay. Therefore, this powerful office of CERT-In has been lying dormant. Okay. But suddenly it appears in the last 3 months, CERT-In is giving out guidelines. Okay, saying that within 6 hours you should give me the data breach. Okay, notification, and also a list of incidents which have to be reported to him, which includes certain things which are privacy oriented, certain things which are information security oriented. Okay, targeted scanning information, malicious attacks which may be there, and phishing, for example, impersonation attempts. Okay, now these are all things which I don't know many companies may or may not record it as incidents in the incident management register. Now you have to check your incident management register and see whether if there is a phishing attempt happening to any of your customers or about your company, is there a record in the incident management register? If there is a website which has been opened with a name which is similar to your organization, is it an attempt to do phishing? Is it an incident? Is your current incident management policy takes care of that? You have to think about it. There are many organizations who use multiple, say, domains. Anybody from Karnataka Bank here? I keep conducting programs for them. Karnatakabank.com is their main website, domain name. But internet banking goes into something at ktkbank.com. Okay, totally different domain. And with, of course, another subdomain, which is called MoneyClick. MoneyClick is a brand name of a US company. Okay, now they have picked up a brand name which is a trademark and a domain name which is not the principal domain name of the bank and created the internet banking. Now there are many banks who might have done that, okay. But remember that for the customer, how will he know that ktkbank.com and karnatakabank.com are same? Does it not give rise to some kind of, possibly these people like us who are, say, more concerned, we may think that there is an issue there. So there are certain things of that nature which certain will perhaps today take more action. So even though PDPB 2019 has been withdrawn, ITA 2000 cannot be easily withdrawn. Though I think ministry wants to withdraw it, and they have said that they want to replace it with another comprehensive legislation. Now he was talking about Kichdi, now we are having a super Kichdi because we want to add data protection law with Information Technology Act and telecom regulations also perhaps, okay. Now how do you combine, see earlier it was personal data and non-personal data combined by the JPC. Only one provision they wanted to combine, which was reporting of the data breach. So when you are reporting the data breach, don't distinguish between personal data and non-personal data, report it to both the Data Protection Authority of India, and CERT-In was already there in the back behind. People, in fact, PDPB discussion never recognized that data breach should also be reported to CERT-In. So that's why I think somebody in CERT-In got worried that nobody is remembering my presence. Okay, actually the JPC could have said personal data breach responses would come from Data Protection Authority. Responses to non-personal data breach, though for information's sake would be given to Data Protection Authority, it also has to be given to the CERT-In, and he will give directions later on. And the current jurisdiction of CERT-In includes personal data breach also. Unless by law you segregate and say DPA will take care of personal data breaches and CERT-In will take care of non-personal data breaches, law actually recognizes a role for CERT-In. Since that was not done by the Data Protection Authority, there was an issue, okay. I feel that it happens in bureaucracy, okay. So they suddenly woke up and started issuing guidelines, and we have today a recognition that CERT-In is there. Now, I have seen many companies actually recognizing the existence of CERT-In only after this 28th of April guideline. So when they gave time up to June, they were not ready, and now that 26th of May or so, even the extension given for SMEs and on the maintenance of KYC for 5 years, that portion, extension was given, that also is extending shortly in September. And you will all have to have a contact person 24/7 available to CERT-In, and his name and address should be mentioned. Now today, whenever we look at compliance, I look at the website. If you look at the website, if you don't have a DPO, you don't have a compliance officer mentioned there, it means that prima facie there is at least one element of non-compliance, okay. So that is how CERT-In has become important. So there is no vacuum. Now many companies have become complacent. In fact, some companies had appointed DPOs. Now I don't know whether they have been checked out now after this act. But CEOs would be perhaps thinking, why did I issue an order at such perhaps higher salary level? Now suddenly government has withdrawn, and we know the government, even though it says next month, next budget session, it may never come. Okay, so should I continue to invest in the DPO? Should I continue to invest in the PIA assessments? These are the issues which companies will be thinking of. But remember, there is no vacuum. ITA 2000 existed, and it will continue to exist. Removal of ITA 2000 has to be by a parliament action. Until that, it will remain. In fact, government need not have removed this. Instead of that, they could have kept in abeyance like it was for last 2 years. And when they were ready with this new law, They could have just switched on the parliament this thing and said, this new law will replace this. Then there would have been less confusion in the marketplace, but somehow they chose this. Now, for the last few days, last 1 week at least, suddenly all ministers are talking about the bill will come next month or something like that. I don't know what has happened. Some people say there was a news report which went viral in the international markets saying that India doesn't have a data protection law, which we already said. The moment he withdrew, we said this is going to be the perception of the international market. Now, not only Mr. IT Minister, even Finance Minister in one of her speeches, she said we are going to have a personal data protection draft soon. So probably they will come up with this. But the current indications are that there will be something called Digital India Act, which will be a comprehensive and perfect legislation. Okay, I don't know where there is any perfect legislation, but they want to do that. Okay, now, then there will be this new telecom bill, then new data protection bill, so ITA 2000 replacement, and a national data framework for cyber security. We don't know whether all of that will come to one particular law. At least that is the statement they have made. We are going with the presumption that it could be done. So when we are looking at designing the new law, I am trying to say, okay, let us start with chapters. Then later on, if one chapter has to be made into a different law, let them do it. Okay. So the reasons given for withdrawal of the bill, of course, is that we want to make this relevant to the times. Whatever was done, at least ITA 2000, they said it is not relevant to the time, because it was done in 2000. Now we have got new technology, but I have a different perception. If you know how to interpret law, you can interpret law even to the current extent. Now today, if there is a ransomware attack, in 1998 or 2000 when this draft was made, we had not heard of ransomware, at least I had not heard of ransomware at that time. But current law, ITA 2000, can effectively handle that by saying that you have reduced the value of information residing inside the computer, because you have, and also you have caused denial of access to authorized persons. So they are all covered under Section 66 of Information Technology Act. You can invoke Section 66. If you can find out the person, you can put him in jail. You can also perhaps provide civil compensation. And if the system happens to be a nationally critical resource, you can call that as cyber terrorism and put a person behind bars for life. Now, it's all a question of interpretation. Lawyers know that they can argue either way like that. So, Information Technology Act can be interpreted to the current situation, and there are many things which actually are open-ended there. For example, attribution of an action to a computer for automated activity is recognized as the activity of the person who caused it to behave so. So you have your AI algorithm. When it comes to law, I will say who is the person who caused the AI to function in a particular way. That person is going to be responsible for the actions. He may be the CEO of the company which today owns that AI algorithm, or that person may say that whoever supplied me this algorithm, he never told me that this is a functionality, and therefore I was sold an AI, features of which I was not aware. Some backdoors were there, I was not aware. So therefore the responsibility should be with the software supplier. Either way, for a victim, I don't mind if my money comes from the AI software owner or AI developer. It's like an intermediary. When we lose money from the bank, we ask the bank to pay us the money. Then the bank can go ahead and find out who actually took the money and repay. I am not bothered about that. So Information Technology Act has got such system of considering attribution of an automated activity of a computer to the person who caused it to behave so. So therefore, most of your AI, ML, robotics, now yesterday we saw that some Chinese company has created a AI-led CEO. You are aware of that? A metaverse company has appointed a robot, humanoid kind of robot, as the CEO of the company. Now, if that is done in India, I don't know whether the Ministry of Company Affairs will register that company or something like that. Okay. Now, these are all fantasies, but in law, I will say, who is behind this robot? That is a person who our law recognizes as the owner. You may give a face, but that is different. So that is the power of current Information Technology Act to address the emerging technology environment. People are talking about metaverse. There was a case which is reported that a lady actually complained that her metaverse avatar was abused by another metaverse avatar. Okay. So the complaint was filed. So people are worried how to handle this in law. Should it come under POSCO, etc., whatever is that. Okay. Now, the question in our law is, I am not bothered about the avatars. Who is behind the avatar? That becomes my actors. Okay. The complainant has to be the victim avatar's owner, which has to be revealed by the metaverse platform, which is the intermediary. We have got intermediary guidelines, otherwise intermediary will go to jail. Then similarly, the metaverse avatar which abused, that offense will be of that person who owns that avatar. Now again, people may say that is not visible, but metaverse platform owner knows who is the person who is representing in avatar 1 and avatar 2. So you call him to the court, he has to provide that information. Otherwise, you consider that he himself is the person who has to be charged. That is how the current law is good enough to be extended to the advanced technology situations. Other than that, this 81 amendments, recommendations were cited as one of the reasons. But who were there in that committee? Our current MOS was one of the persons who was sitting in the committee. I made the presentation to him. So, how is it possible that you reject all these amendments today? Because these amendments were done by the same persons who are today calling that as difficult. Anyway, users continue to have rights to their data, hence consent mechanism remains as important, which is a statement which has been made by the minister, which means that there is not going to be a change in the consent being the main you can say lawful basis for processing of personal data. Every citizen will have a grievance redressal. So this is something which has come to every law today, Information Technology Act, intermediary guidelines, everywhere government is trying to say. It's very important to provide grievance redressal mechanism, then consumer complaints will come down. So that will be one of the things which GDPR did not highlight it much, but we are highlighting it. So, if you look at this, in fact, the shape of things to come is to some extent indicated by what these ministers are talking. Okay? So, I am saying that as far as AI, ML, robotics are concerned, current law itself is having enough powers. Sometimes lawyers in the court say, unless it is exactly mentioned, they will confuse the judge. So that is why our old Income Tax Act used to have clauses after clauses after clauses to address every judicial decision. It should not be actually done. Judges also should think that they can interpret it. They have been given the powers to interpret. Let them interpret it. Every interpretation of the judge need not become a new clause. At best, it can be an explanation. There is no need to amend. Okay? So that could have been done. What is required perhaps is, being with the times, there are something called neuro rights which you are been hearing now. See, our privacy rights today stops at managing the choice of the data subject. So as data processing companies, what we do, we ask the data subject, I want this information, are you willing to give? What you want to know is why I am asking it, and I will give all that information, but I want to see your SMS, I want to see your photo, I am asking for permissions, and if you give the permissions, it's okay. So that is the right of choice. The privacy protection in India as well as elsewhere is actually protection of the right of choice of the data subject for what data can be collected, what data can be, how it can be used, how long it can be retained, all these things. Now, this right of choice is an activity of the human brain. Now, if there is a technology which changes the activity of the human brain, then the right of choice loses meaning. Remember the Cambridge Analytica kind of an issue, which also continues to have effect in all advertising kind of instances. Whenever data is used in the form of a profile, what Cambridge Analytica did, of course, not taking permission is a different issue. It could have been taken. Now, otherwise, how did they use the information? They created a profile. They created whether he is likely to support Trump or likely to support Biden. And then advertisements were designed to actually convert their opinions, okay, which is part of every advertisement. Today, if you are not buying Coca-Cola, Coca-Cola advertisement will say it is the best thing for you. It will try to change your mind and change from your current preference to that, okay. So Cambridge Analytica also did that. This is the right of choice was being manipulated. So that became an international issue. Now suppose I can directly get into your mind by a chip or by an external radiation. The neurotechnology is actually putting a chip either externally or inside the brain. Sometimes that is medically recommended because there are certain diseases like Alzheimer's and epilepsy, which medical science says that it can be cured by putting a chip of some sort. Now, if you allow computers to interact with human brain, then that can also interact and change your right of choice. Whether you want to choose Trump or Biden, that software will do it. You don't have to take a conscious decision. So this is neurotechnology which is coming up. So worldwide now a discussion has started that beyond the current privacy rights restricted to right of choice, we need to protect the right not to allow the human brain functions to be intervened by external computer devices. BCI, that is the brain-computer interfaces, should be regulated. So now, Chile is the only country today to have this as a form of law. We want India to be the next to this thing, but it can be part of this proposed law, according to me, as long as we know that this is the next level of privacy. Okay, we know physical privacy, that is, a person should have a choice, like Karak Singh judgment, if some of you are aware. Karak Singh Supreme Court judgment was that police or somebody should not infringe on the rights of a person. People should not visit him at night or something like that. It is called that a man's residence is the castle or something like that, the judge said, and nobody should interfere with that. The same thing got extended in other Supreme Court judgments until this Puttaswamy judgment came and said that under this right to life and liberty, right to this choice, right of choice, should also be recognized as the privacy right. But now we are now going beyond that. So neurotechnology is a threat, and protecting the neuro rights could be one of the things which we can address during this. Now we are talking of blockchain technology. Blockchain technology leads to bitcoins and cryptocurrencies. Now, though blockchain is always talked about as a technology platform, as nothing to be done, people don't talk about blockchain exclusively. They always talk with Bitcoin. Even metaverse today, metaverse world wants to use cryptocurrencies for any transaction. I have no problem in a metaverse website doing transactions in legacy currencies. But the moment they say I will use a cryptocurrency, then we will evaluate the legality of that metaverse activity or that blockchain activity from the point of view of the cryptocurrency usage. Because cryptocurrency usage is outside the radar of the current financial systems and could lead to collapse of the economic system in the whole world. And therefore, it is something which has to be regulated to the extent that it cannot be misused. Okay. So blockchain technology otherwise fine as a platform, it can be used. Metaverse, as long as it does not use cryptocurrency, is fine. But these are the things which needs to be addressed in this upcoming law. Now, consent mechanism, this is what I said, right of choice has now got into this right to interfere the brain functions of the persons. Please study that in depth. It's an interesting this thing. I have also opened a separate website called neurorights.in so that I can put all my thoughts there. I have this habit of creating a website, and whatever thought comes to me, I will put it there. Then after 6 years, now our Naavi.org is a 20 plus years old content aggregation. It gets value, like your, what is that, wine, old wine, okay? So by aging, it gets value. Now today, if you want to have a copy of the E-Commerce Draft Act of 1998, you will not get it from the ministry site. You have to go to Naavi.org site. So research and other things. Likewise, neurorights also have started putting whatever thoughts. Not all of them may be correct sometimes, and I may myself, I'm a learner, but that is how I think knowledge has to be accumulated, and that is education. Education sometimes will be creating an environment for people to learn and put things. Now, other recommendations of the JPC which are likely to continue into the new law, now right to forget. Now, right to forget under GDPR, the decision maker is the company. In India, right to forget is recognized as a right, but companies cannot take a decision on right to forget. You have to get the approval of the adjudicator. That is the current this thing. I feel this will continue. Right to grievance redressal is an important aspect, which will also continue. This is again there as part of our PDPB 2019, it is likely to continue. Now, when it comes to cross-border transfer, currently what we said, explicit consent is required. For non-sensitive data, there was no regulation in India in the PDPB 2019. In PDPB 2018, which was Sri Krishna's this thing, there was some control on non-personal data being transferred out of India. PDPB 2019 had diluted it. Non-personal data, no restrictions. Personal data subject to one copy being kept in India and consent to be taken, permitted. Critical data, not permitted, but still critical data itself was not defined, so we don't know where it will apply. Now that is a matter of discussion. Industry doesn't want data localization. They want the data storage business to be only outside India, but data localization will give enormous business potential in India. Even yesterday there was some mention that some 45 data centers are going to be opened or something like that. All that will happen if the data localization is there. And law enforcement has always been asking about this data localization. So that is likely to continue according to me. Not much of a relief will be there for the industry. Now, algorithmic transparency was one of the things which PDPB 2019 suggested. In US and others also, there is something called bias prevention. So bias audit has to be done. And the same thing had been adopted here. So I feel that also, as a matter of assurance, that is, algorithms need to be assured by way of somebody in the company signing a document saying that this does what it is supposed to do, not anything other than that. So some kind of an assurance. That assurance means that there is so much of business to the information security people to look at the algorithmic audit. Okay. So that I feel may continue. There was something called cyber security certification that no device which is processing the personal data shall have any malware in the process or device. That was objected to by the industry because what they mean is all the backdoors and other things will have to be declared, or at least it should be disclosed. Now all Chinese software has a backdoor, okay, we all know. Now I want somebody, the law said that should not be there, which only meant that it should not be there without your knowledge and consent, that's all. So if you agree that the software hardware supplier needs a backdoor because of maintenance and other things, if you agree, then it is a transparent way of doing business. I'm not sure whether it will continue or the government will develop cold feet and stop it. Now, these are all the things which all of us we know. Now, we will go to one additional area where I am trying to add new things into this proposed law as a suggestion. This is where professionals like you should also start thinking. For example, profiling and right to portability should be de-linked according to me. Say now I am going to certain things which you may not see in GDPR or anywhere, so it is just, you can say, Naavi's theory to be adopted kind of a thing, recommendation, okay. Now what do I mean by de-linking profiling and portability? Now you know that according to the current laws, if an individual has given his personal data, you as a company build a profile over that data. That built profile is a value addition which you have done with your experience, money, etc. Now, IPR should be recognized on that value addition. Now, data portability says that if the data portability right is exercised and you are asked to transfer that data to somebody else, that is either the data subject himself or to a third party, then that should be transferred along with the profile built by the first processor. Which means that if I am a customer of, say, Airtel, and Airtel has built some profile about me so that they can give some better service. Now, I want to shift my SIM to Jio. I say, please transfer even my profile which you have created, which may say that what is my usage pattern, do I call more in the morning or in the evening, or do I use more broadband in the morning, afternoon, this thing. These are all important things. I'll say, please transfer that also to Airtel or Jio. That's where the IPR things come into play. So I feel that profiling and this should be segregated. If you really want, then take permission for that from the data subject. You say that I am going to create this profile. Now, are you giving me permission to keep it separate, or you want me to return it back to you? In real estate, this sort of a thing is all normally there. If you lease a land to somebody and then permit him to build a building, now after the lease period is over, whether that building has to be returned to the landowner or it should be demolished and clean, this thing has to be returned, this is part of the contract. You can enter into a contract and say building will become, it will be returned to the landowner. So same way we can do. So this has to be built into the profile. It should not automatically mean that any value created should automatically be part of the portability. Particularly portability includes transfer to a competitor. Delinking system visibility from right of privacy. What I mean here is that, see, you have heard of the terms automated means of processing. Automated means of processing is subject to consent according to GDPR. Okay. Of course, digital information, the whole act exists because of automated processing. Now, there are certain processes. Suppose I create a process. I take identified personal data, process it in this algorithm, and in the output, I give reports which are anonymized, which doesn't have the identity. Then is there a privacy infringement there? This is the big data analytics kind of a thing. I think somebody was discussing today whether, I think I read somewhere that whether data analytics and privacy can coexist. Okay. Every data analytics where personal data is involved involves churning the identifiable personal data. Now, when it is returned back to the user, whether it is in identifiable form or anonymized form, that makes all the difference. If you are giving the processed information back to a human being, then if the processed information is visible to a human being, then there is an issue of privacy. Therefore, you have to take consent, etc., becomes essential. But suppose I have created an algorithm which even the algorithm admin does not know the output to whom it belongs. Okay, I just create an anonymized output. Then why can't we leave that as the discretion of the big data company to process such data is a thought which is giving here. Maybe you have to think further why I am talking about this. The idea in all data protection laws is we have to find a balance between this data subject, his privacy rights, the business which has to make money, and the government which has to take the security of the country. You cannot create a law exclusively about data privacy. Give anonymity. Like all criminals are the best advocates of privacy because they can do things and then claim privacy rights. Security is not like that. I would like to know about the identity of the person. In between, the processing has to take place that a genuine person's privacy is not misused, but at the same time, a person who is not entitled to that is probably taken into account. Okay, so that's why I say regulated anonymity and regulated pseudonymity is what we have to promote, not anonymity per se. Pseudonymity, of course, no problem, because pseudonymity essentially means that you still are having capability of re-identification, and probably the intermediary guidelines powers will be used there. If an organization says, I've pseudonymized the data and I've released it, you cannot know whose data it is. Therefore, there is no infringement of privacy. But law enforcement can give a subpoena and then collect the information. That's possible. So regulated anonymity means it will be, of course, completely anonymized. Anonymity essentially means you cannot reverse the process. Pseudonymity can be reversed. But there can be regulation which makes it impossible for the government to get back the information. So this is something which certain processes you can see in old Naavi.org articles, 2005 or so, I have discussed this anonymity, regulated anonymity, similar to the domain name, distributed domain name system, where the keys of the domain name servers are held by different people, kind of a thing. So just, there is a possibility. Now let us stop at just giving an idea like that. Then making data valuation visible and prevent data laundering. What do we mean by that? When, say, I would like Mr. Chennai to also go through the framework or standard which we call as Data Protection Compliance Standard of India, DPCSI, where we have, of course, mapped that with 17428 and other things. One of the things which I have introduced is, if you want to call data an asset, then you should make it visible in your balance sheet. Otherwise, how will the CEO know how much resources have to be put in? Okay, so in order for the management to get an idea of what kind of assets value they possess, there should be some way of data valuation. So we have adopted that as one of the controls, suggested controls. A company can always say, I don't have data valuation. I can't do anything because it is not mandatory. But it's a best practice kind of a thing. We want that to be visible. For example, a company today comes to know of the value of the assets only when there is a ransomware demand. When Air India was hacked and somebody asked for 6,000, say some bitcoins, then only Air India management woke up and said, oh, I never knew that I had so much of value of data. It should not happen. I want the data valuation should be something which should be visible to the management. And data laundering, okay, what I mean by data laundering is money laundering, we know. Data, if it has got a value, there are organizations worldwide which are trying to steal the data. The best example of that is CIBIL. Okay, CIBIL was started as a 90% bank-owned organization to exchange credit information so that NPAs could be less. Today, 92% of the shareholding is owned by TransUnion, which is a listed company in US, private sector. Which means that the 500 million data sets of Indians, they have the control. So we know in mergers and acquisitions, people acquire only because of the underlying assets. Okay, if you have got land which is not brought into the balance sheet, a company will buy it, knowing that even our okay, National Herald case is like that. Okay, so data can be a laundering instrument, and our law should put some prevention of that. Creating an indigenous code of practice for compliance is also something, because we have got something called Code of Practice, Section 50 of PDPB 2019. There is already a provision. GDPR also has a provision. So I feel that that should be strengthened. That is where FDPPI interest will be also there. We are trying to create a framework which is the essence of the other essential best practices. Nothing, all these things are also there. We are trying to do something. So with this background, I have tried to say that this new law which has to come could have this, even chapterization we have tried to give. Basically here I am assuming that, say chapter 1 will be preliminary, chapter 2 privacy protection for non-digital environment. Today we are all going back to Article 21 and interpreting the Supreme Court Puttaswamy judgment to say right to privacy is part of. Why can't the government by a law say, I recognize the right to privacy? This was there in the 2008 version, which draft which never happened. So I will one chapter, we will say right to privacy is recognized. Digital privacy is in the further chapters. But in the first chapter somewhere we have to make a mention. Chapter 3, governance framework for personal data. Chapter 4, governance framework for non-personal data. Government says, I will have governance and protection combined in this law. So governance function is different, protection function is different. Chris Gopalakrishna committee actually spoke about the governance. So I feel that we need to have a chapter on governance and a separate chapter on protection. And the protection of personal data and non-personal data can be combined. That is what I have said in the chapter 5 and 6. They will actually have a combination of personal data and non-personal data, and non-personal data protection is nothing but a replica of ITA 2000. Personal data protection could be your section 24 of PDPB 2019, reasonable security practice and so on. Then data valuation framework and miscellaneous aspects. This is the kind of chapterization which I have looked at. Another important aspect is about the regulator. I am envisaging that there will be a requirement of 4 types of regulators. Regulator for personal data governance, regulator for non-personal data governance, a common regulator for protection of both personal and non-personal data, and the regulator for all legal aspects like adjudication. And these 4 regulators can be under the super regulator, who can be provided assistance through an advisory board, is the regulatory structure I am thinking of. And definition of privacy should include physical privacy, mental privacy, neuro privacy, and information privacy. Today we are just, remember Puttaswamy judgment, whatever we are interpreting, they are all in what we call as arbiter dicta. That is, in the document explaining the decision, different judges have spoken, and in the final order, one-page order, there is no mention of what is privacy, etc. That is exclusively, the order is related to certain 1, 2, 3 points. MP Sharma judgment overruled. Privacy is fundamental right under Article 21 with reasonable exceptions. That is the final order. But rest of the things we are interpreting, because Chandrachud said something like this, Chelmeshwar said something like this. So we are actually giving scope for too much of vagueness in various definitions. It is better if it is brought into the law. Let the government decide today that culling out from all these discussions, this is what I call as information privacy, this is what I call as mental privacy, this is what I call as physical privacy. Then in terms of roles, I have got one suggestion. We today have data controller, data fiduciary. Okay? GDPR said data controller. Controller takes all the instructions, then controls the data subject. Okay? Indian law did not like that controlling. They said you are a trustee, data fiduciary. But now, if you are a trustee, then I expect a lot of things from you. Actually, I don't need a law at all. I can say trustee should know what is good for me and he should implement. So it has to be balanced between the two. So I feel the role has to be redefined as a data manager. We already have a consent manager, which is a good role, intermediary role, to take care of these consent problems of language and other things. Data storage agent. I want to look at companies who does nothing but only data storage, not to be considered as a processor. Say, for example, I just take encrypted data from you in a hard disk, keep it in storage and return it to you. Why should I be considered as similar to a data processor? Because I don't go into the data at all. So, data collector and a data storage agent, they have some roles. In between, you have got the data controller or the person who decides how to use the data, data processor who processes it. There are 4 actual roles. This distinction has to be brought into this. Similarly, data has to be actually recognized as personal data, non-personal data we are already doing. Sensitive personal data and sensitive non-personal data we can do. Similarly, critical personal data and critical non-personal data we can do. By doing this, your offense sections get automatically defined. Say now we have got a section 66F or something to say life imprisonment for cyber terrorism. I can say something is a critical non-sensitive data, any offense related to that is life imprisonment. So some simplification is possible. Joint data needs to be defined. Business data, corporate data has to be decided because there is confusion in the GDPR scenario about proprietary concerns. Data of proprietary concern, is it a personal data or a corporate data? There is confusion. Joint data is when 2 people actually share the data like a telephone call. Then, just 1 or 2 minutes, okay. That needs to be looked at. Then data of non-citizens, should it be covered under our law? EU says residents or something like that. It only causes confusion. Let the law say whether non-citizens are protected under Indian data protection law, because Indian data protection law is to protect the fundamental rights of our citizens. So de-identified, pseudonymized, all these need specific definitions, and harm is defined now. Monetization also should be defined, otherwise this IRCTC kind of confusion will come. A company wants to actually conduct a survey on what is the value of data I am having, you call that as monetization and go to the court and prevent it. That is not proper, so monetization has to be done. And in terms of profiles, normally what we are dealing with is behavioral profile, financial profile, health profile. Advertising profile also is another kind of profile which should be regulated with a specific definition. People want cryptocurrency to be regulated with a definition, then advertising profile also can be defined. Okay. Machine processing I have already discussed, and there is one concept which I have introduced as privileged communication, just for handling, you just look at it. Now this new draft, we are going to discuss in IDPS 2022. I want ISACA to join us in this particular program and contribute towards this so that we will be able to have something available to the government as a feedback from the industry. So friends, this is where I will stop. There are already 2 bells, so if you have questions, I am willing to answer, but anyway, I leave it to the organizers. Thank you.
Thank you, sir.
Yeah.
Thank you, Naavi, sir. I'll just limit to 1 question in the intro, because we are sitting between lunch on this thing. Mohan.
No, sectoral guidelines are there from Reserve Bank of India, for example.
Pardon?
Reserve Bank of India has got sectoral guidelines as far as licensed bankers' data is concerned. So, and as I told you, 43A has a mention that it can be transferred only to such circumstances where its security is adequate.
43A under IT Act.
IT Act, you have to go to the reasonable security practices rules, which was issued on April 2011, and in that somewhere hidden is this, there are 8 paras I think there, out of which somewhere this consent and this cross-border data was something which had escaped most of the people's mind. It is there.
So the restrictions still remain even though the PDP Act has been temporarily withdrawn.
Yeah. In fact, PDP Act would have been a due diligence under Information Technology Act. It is the best practice because if it had come, 43A would have been removed. This should have sit in its place. So implication was very clear. This is an extension of ITA 2000. And that did not happen, which means that there is certain vagueness. It is like an act coming without the rules. You remember 2008 amendment was passed from October 2009. Rules came in 2011. Does it mean that the section was not operative during this period? No, sections were operative. But there was no government guideline on reasonable security or something like that. Likewise, now PDPA has gone. It doesn't mean that you don't have to take consent, etc. as given here. In fact, at least 3 courts have quoted PDPB 2018 and 19 in their judgments already before it was withdrawn. So it is a best practice. Don't destroy that draft. You keep it for your compliance reference.
Thank you.
Okay. Yeah. Say, if you are now you are talking. What you talk, I am supposed to hear. Now, can you claim privacy for that and say, no, this is my conversation, you cannot hold a copy? Conversation on telephone is also like that. Both of us are conversing. That conversation is a joint property. That's where I said we have to define a joint data. You also have the right, I also have the right. Of course, neither one of us have to misuse it to create harm for the others. But don't tell me that I need a consent to record. Okay, then you are putting a restriction. This is what US perhaps wants. Okay, I am saying that it is, the conversation is a joint property. If I don't ask you a question, you will not reply. So your reply is conditional to what I ask, is it not? So therefore, this should be declared as jointly owned data, personal data, community data. In fact, Mr. Gopalakrishna committee did talk about community data. Now, the transactions which are happening in this, all of us have got some kind of a right. You have raised a question, it goes into the recording. Now, ISACA has to say that I have the right to use this. You cannot block your face or block your voice, kind of a thing. So, we have to recognize jointly owned personal data, community owned personal data. These are things which have to be there. Sri Krishna committee, Sri Krishna said that these are things which we are not able to do. It has to be considered later. It is there in his detailed report. So that is what I am suggesting. Okay, I am going to be here until 4 o'clock or 4:30 before the Shatabdi goes back. So I am willing to interact with any of you during lunch or something like that. I will be happy to answer the question. I don't want to disturb that.
Yeah, thank you, sir.
Schedule.
Really appreciate your time. Can we get ready for the polls, please? Bring out your voting pads. I mean, I've had the privilege of interacting with him in a different forum as well. We pick his brain, and some of what, from a privacy perspective, also comes from him as well. In fact, I had a privilege of doing a data privacy impact assessment workshop here as well. So some of it comes from his school of thoughts, as what Nandakumar Shenoy was talking about. So can we get ready for the polls? Thank you. May I request Mr. Janardhan to be on stage, please? Sir, Naavi, we would like to present you a small memento. Please be on stage.